Hi, my name is Cameron Fredman. I'm an attorney, and in this video I wanted to talk about this idea that we've seen from tweets from President Trump, even from the beginning of his administration, about the idea of sending the feds in to cities like Chicago, Illinois. Of course, in recent days we've seen something like that happen in Lafayette Park in DC at the beginning of June. And recently we've seen that happening, or something like it, in Portland, Oregon, and now there's discussion of something like that happening in Chicago, Illinois. Now it turns out this is a big topic, of course, and it matters who you send in. So if we're talking specifically about the military, if we're talking about the National Guard, it raises different legal issues than if you're talking about, for example, the Federal Protective Services, or INS, or Border and Customs. So what I'm going to do is this video is going to focus specifically on the military and the National Guard, which was implicated, as we remember, at Lafayette Park in DC. I should mention before we begin, though, that if you like videos like these, if you want to encourage more of them, please go ahead and give a like or subscribe below, or leave a comment letting me know what you think. It really helps encourage making more videos like this. On June 1st of this year, President Trump announced that he would deploy the United States military to U.S. cities and states if they didn't take certain steps.
If a city or state refuses to take the actions that are necessary to defend the life and property of their residents, then I will deploy the United States military and quickly solve the problem for them.
Now, the starting point for this type of analysis is something we call the Posse Comitatus Act of 1878. It's a law that forbids the use of military forces to enforce the law domestically. There are exceptions, and I promise we'll come to them. There are a lot of exceptions, in fact. But the starting point is to understand that it is illegal to use the military to enforce domestic law, unless you're in one of those exceptions. So how did we wind up with a law that forbids the use of military force domestically? Well, this dates back to Reconstruction after the Civil War. After the Civil War, U.S. forces were used to enforce the law in the South. And those southern states, those governors and legislatures, didn't like it. Essentially, it's the idea of they wanted the ability to have local police enforce the law locally. It's essentially a states' rights idea. Here's the law, 18 U.S.C. 1385. And the one point I want to make about the law specifically is that it is a crime. One can theoretically be charged with and serve time for a violation of the PCA. But just because it's a statute doesn't mean the idea is limited to the statute. In fact, there's an argument that the idea of separating military force from civilian law flows from the Bill of Rights. The Second Amendment arguably provides for a civilian militia. The Third Amendment prohibits quartering of troops. The Fourth Amendment prohibits unlawful searches and seizures. And I'm not the first person to make this observation. In fact, the United States Supreme Court, in a case called Laird versus Tatum, 1972, said it is not unreasonable to believe that our founders' determination to guarantee the preeminence of civil law over military power was an important element that prompted adoption of the constitutional amendments we call the Bill of Rights. By the way, this is a case worth taking a look at. It had some very strong language regarding the use of the military, in that case, to surveil Americans. This case involves a cancer in our body politic. It is a measure of the disease which afflicts us. Army surveillance, like army regimentation, is at war with the principles of the First Amendment. Those who already walk submissively will say there is no cause for alarm, but submissiveness is not our heritage. The First Amendment was designed to allow rebellion to remain as our heritage. The Constitution was designed to keep government off the backs of the people. Now let's go to the present day, or at least close to the present day. On June 1st of this year, 2020, there were protests happening at Lafayette Park in Washington, D.C. Now, Washington, D.C., and in particular Lafayette Park, have a long history of protests occurring there. They've happened to just about every administration, and they cover whatever the issues of the day are. But June 1st was unusual because on June 1st, federal forces were used to disperse the crowd. apparently to make way for the president to engage in a photo op at St. John's Episcopal Church, located across the street from the White House. Now, the federal forces used included the use of the National Guard, which is military for the purpose, for example, of the Posse Comitatus Act. And we also saw that General Mark Milley was present as part of the president's entourage, and we saw that the Defense Secretary, Mark Esper, was part of the president's entourage as well. So that brings us to the first legal question here, which was, on June 1st, did the clearing of Lafayette Park constitute a violation of the Posse Comitatus Act? And actually, in this case, there's an easy answer, and the answer is no. It probably did not constitute a violation, but it's interesting the reasons why. Washington, D.C. is special. Remember, Washington, D.C., at least currently, there's a movement to change this, but Washington, D.C. is not a state. In a certain sense, all law in Washington, D.C. is federal law. Not the only argument for why the actions at Lafayette Park don't constitute a violation of the PCA. Some of the other arguments that were raised have raised eyebrows, however, though. And I'll give an example. On June 9th, Attorney General Barr sent a letter to Mayor Bowser of Washington, D.C., in which he argued that the National Guard was deployed pursuant to its authority under 32 U.S.C. Section 502. Here's that statute. That's a statute that authorizes the National Guard to conduct drills and training exercises, or drills and field exercises. You can imagine, I don't think the administration wanted to defend that particular argument in court. One could imagine that a federal judge would conclude that it's not a training exercise when you have unwilling participants, particularly unwilling participants who are engaged in constitutionally protected activity, protest. Now, on that day, on June 1st, in addition to this action happening, President Trump seemed to be announcing that the same tactic or something similar would be deployed to other U.S. cities.
If a city or state refuses to take the actions that are necessary to defend the life and property of their residents, then I will deploy the United States military and quickly solve the problem for them.
And as you can imagine, these arguments wouldn't likely extend. Certainly the argument that it's not a state isn't going to apply to states like Oregon or Illinois. And the idea that a training exercise is going to cover sending troops into other cities probably worried people in the military. I'm not trying to read their mind. They made statements. Here's, for example, General Mark Milley the day after this happened.
Always maintain a keen sense of situational awareness. As senior leaders, everything you do will be closely watched. And I am not immune. As many of you saw the result of the photograph of me at Lafayette Square last week, that sparked a national debate about the role of the military in civil society. I should not have been there. My presence in that moment and in that environment created a perception of the military involved in domestic politics. As a commissioned, uniformed officer, it was a mistake that I have learned from, and I sincerely hope we all can learn from it.
Now remember, I mentioned there are exceptions to the PCA, and there are a lot of them. I'm not going to go into all of them. It's stuff like the military can do aerial photography. The Coast Guard is allowed to operate during peacetime. The Navy is allowed to support the Coast Guard in pursuing certain types of suspects. There's an exception for the war on drugs. There's a host of exceptions, but by far the biggest exception is the Insurrection Act of 1807. This is an exception. You know, sometimes we talk about an exception large enough to drive a truck through. This is that. This is a large exception because the Insurrection Act of 1807 empowers the president to call in U.S. armed forces and the National Guard domestically. Now, the Insurrection Act comes with strings attached. There are certain requirements under the Insurrection Act, and I'm going to explain them, but I wanted to first give you an idea of the existence of the Insurrection Act so that you understand why, when Defense Secretary Mark Esper, who also made a statement, just like General Mark Milley did, what he's talking about when he refers to the Insurrection Act. Here's Defense Secretary Mark Esper right after what happened at Lafayette Park.
I say this not only as Secretary of Defense, but also as a former soldier and a former member of the National Guard. The option to use active duty forces in a law enforcement role should only be used as a matter of last resort and only in the most urgent and dire of situations. We are not in one of those situations now. I do not support invoking the Insurrection Act.
So you might be confused at this point. After all, I told you first that the PCA forbids the use of the military to enforce domestic law, and now I'm telling you that the Insurrection Act allows the president to use the military to enforce domestic law. Which is it? It's a fair question. I guess the thing to understand about the Insurrection Act, or where I want to start, is with those strings that might be attached to it. Obviously, there are political strings attached. You saw some of that when the military leaders like Defense Secretary Mark Esper and General Mark Milley oppose its use. That's a political ramification of invoking that act. But there are some legal ramifications too. For example, the president has to issue a proclamation that the insurgents disperse first. Now that's not hard to imagine that being implemented. But the more interesting issue is the question, and this brings us to our next legal question, is whether the Insurrection Act requires an invitation by the state in order for the act to be invoked. Now, this is an important question in particular to what's happening today because, for example, Oregon Governor Kate Brown has made very clear that she does not support the use of the federal military in this manner.
I don't believe that President Trump ordering troops to the streets in Portland is the solution to the challenges we're facing, and I would ask Portlanders to not take the bait.
So to answer the question of whether the statute requires an invitation to the state, it's always good to look at the statute first. And in this case, there's some conflicting things in the statute on this particular point. For example, if you look at Section 251, there is language that seems to suggest that the request must be made upon the request of the state legislature or its governor if the legislature can't be convened. So Section 251 seems to suggest that yes, the president requires an invitation by the state in order to invoke the Insurrection Act. But I don't want to leave you thinking that it's that clear. If you look at, for example, the next section of the statute, Section 252, you'll see what seems to be the opposite statement. Whenever the president considers that unlawful obstructions, combinations, or assemblages, or rebellion against the authority of the United States make it impracticable to enforce the laws of the United States in any state by the ordinary course of judicial proceedings, he may call into federal service such of the militia of any state and use such of the armed forces as he considers necessary to enforce those laws. So if you only look at Section 252, you'd probably come away thinking there's no requirement of an invitation by the state. If you only looked at Section 251, you'd come away thinking there is such a requirement. The law is not particularly clear on this if you just look at the statutes. I think what is more clear is that the administration is clearly of the view that they are on stronger legal footing if they do have an invitation than if they don't. Here is President Trump talking about the issue. You've probably heard him talk about, we keep asking the states to invite us and they don't do it. Here he is.
We're not going to let it go on. We're not supposed to wait for them to call, but they don't call. We've asked Chicago, would you like us to go in and help? And they don't want to say anything. And we've called many of the cities, would you like us to go and help?
This ambiguity about whether or not it requires an invitation by the state or doesn't makes the stakes very high if an administration sends in military forces and if the invocation of the Insurrection Act is deemed not effective by courts, because you're all committing a crime then. If you don't have a lawful basis under the Insurrection Act, if you're not in one of those exceptions, then you fall under the Posse Comitatus Act and you're just breaking the law and no one wants to go to jail. So I guess one way you could look at the issue or try to answer it is to look at history. And the first question you might have is, has the Insurrection Act been invoked without an invitation by the state, or even against the wishes of the state before? And the answer is clearly yes, it has been. In 1957, after Brown versus Board of Education was decided by the US Supreme Court, that's the case that desegregated schools, the governor of Arkansas prevented a group that became known as the Little Rock Nine, a group of 9 African-American students enrolled at Little Rock Central High School. And the governor of Arkansas prevented them from attending school. Now, President Eisenhower invoked the Insurrection Act and had the U.S. military accompany these 9 students to school. And that isn't the only instance in which it's been invoked like this. For example, President John F. Kennedy also invoked the act and also did so without an invitation by the state and did so to enforce school desegregation. So back then, were Presidents Eisenhower and President Kennedy violating the Posse Comitatus Act? Maybe. Really maybe. We may never know the answer to that question. I mean, we're never going to have a decision on it now. But one can imagine that that's sort of a special instance, because if the state of Arkansas wanted to challenge it back then, if the state of Arkansas wanted to challenge President Eisenhower's decision, that challenge would likely wind up in the U.S. Supreme Court. And it would be very difficult, certainly for the lawyer arguing the case, to argue that the president is interfering with that state's right to violate a recent landmark U.S. Supreme Court decision. Remember, you're arguing to the same people who just decided Brown versus Board of Education. They're not going to be thrilled by a state taking the position that they're not bound by decisions by the United States Supreme Court, one would think. So back to the legal question, does the Insurrection Act of 1807 require an invitation by the state? I think the best we can do is say maybe. It's not entirely clear. Different legal observers have different opinions on this subject. And I think it is certainly possible that federal courts could have gone one way or the other on that issue had it been litigated out. But it was a concern, clearly, by the administration that if what was done in Lafayette Park was taken to cities in states rather than places like DC, which is not a state, that they might face legal challenges of a different nature. I'm going to leave to the next video the discussion of the legal basis for what's happening in Portland, Oregon, currently, which apparently involves the use of various agencies under the Department of Homeland Security, including the U.S. Marshals, the Federal Protective Service, INS, Border Patrol. It's a different issue when you're using those agencies than when you're using the military or the National Guard, because the Posse Comitatus applies to military. It does not apply to these other federal agencies. But that may feel a little bit unsatisfying to you. It does to me a bit, because if you think about when the Posse Comitatus Act was passed, it was to address a concern that local policing should be administered locally. That was the idea of it. I don't think anyone imagined that individuals under federal agencies could become so militarized as they have been, that it is essentially indistinguishable from an army. Can you spot the soldier from the federal agent out of a CAPTCHA, for example? Would you know which one is which? I think that's hard to do, and it does implicate at least the concept, the issues that underlie the statute, though it does avoid technically falling under the statute. For as long as I have been practicing law, at least, I have heard from my conservative friends about states' rights. Lawyers sometimes refer to the collection of rights retained by the state under the shorthand police power. And it is a shorthand. We use the term police power, but usually when you say police power in a constitutional context, you have to give the caveat that we don't literally just mean the police. We mean the ability of the states to regulate the health, the general welfare, the safety, the morals of its state. But yes, it's called the police power for a reason. It also does literally mean the ability to enforce state law locally. It is fundamental. It's the quintessential states' rights right. I hope that some of these states' rights advocates will speak up. It seems to me that now is the time. I also hope that this video was helpful to you. If you like this video, if you want to encourage me to make more of these videos, please remember to like, comment, and subscribe below. It affects the YouTube algorithms and encourages me to make more of these videos. As always, this is all just my personal opinion. None of this is legal advice. In fact, don't get legal advice off the internet. Call a lawyer. And thank you for watching.